Well, Henshaw here again, your friendly local constitutional coop from California. And this video is directed uh, to victims of evictions and mortgages, uh, and foreclosures and things like that. And the good news here is even if you've been through some very negative experiences like that, and I'm sure far better than I do how that must feel, I'm here to tell you that we have ways to get redress to grievance and serious redress. And it doesn't matter. There's no statute of limitations given we can prove deceit, fraud, and treason on the part of the quote unquote landlords or mortgage banksters. And that's a big deal because with that way, it doesn't matter 10 years, 20 years. They knew it was wrong. The black robe bastard that handled the case when we were in one of their corrupt courts had to know this. All of them had to know it, and we can prove it. And the good news now with the U.S. Supreme Court in its fourth term of an all-out assault on the administrative state, and that's what specializes in these evictions and foreclosures, is that we can really have a lot of leverage here, to get you some big settlements. Because the deal is, it isn't just your case. And the way the system works or doesn't work, depending on one's perspective, is if you get a decision in open court, especially in the U.S. Supreme Court, that undoes all the mortgages and evictions from Portland, Maine to Portland, Oregon. That's how good this is, but nobody ever asked the questions. And this is one of the first things I learned in the first law school I took 41 years ago. By the way, never been in UC, Berkeley, Starboard, Bale, anything like that. Long gone, Polytechnic. Learned it on my own. But the Ashwander doctrine of the court, and you learn, one of the first rules, they have 7 of them, and you'll learn more about that later. Send me an email, youwinnincourt@gmail.com. Rule 1, the court will not address an issue of constitutional law in the advance of the necessity deciding it. You don't ask, we won't answer. It sounds harmless enough, but when you understand that no attorney in the Supreme Court bar in his right mind, especially for the last 60 or 70 years, is going to present issues like what we will be doing. And the fact that they consider all of us to be ignorant, and with the public education system, especially being what it is today, they don't teach a damn thing, especially in this area. When I was in school way back when in the 1960s, it was a lot better because it was on the local level. The county board of education controlled it, not the state. But even outside of Washington, D.C., where I went to school, I didn't hear anything like what I'm going to be teaching you. It wasn't there. They don't want you to know that you have rights. You have a real life, and your children have real rights. It's just not consistent with the government we have, going on today, a de facto national socialist government. Learn more, send me an email, youwinnincourt@gmail.com. The important part here, and it's a lot more than money, by the way, because and if we ever get in front of a jury, and trust me, we're never going to see one, I would love to, they're going to get it because they're going to tell the jury, yeah, it's a lot of money here, but we want to make changes to the jurors that will affect you, your children, and your posterity. That's a winner chicken dinner is what that is. And there's nothing the other side can do about it. And the jury is going to get that. That's what we're here to do. And with the jury that has the power to rule on the facts and the law, like what we should have in a common law court, this is a very doable project. So this is a lot of bargaining leverage, and money doesn't solve everything. There's no 2 ways about that, especially with the damages that have been inflicted on young children, with all this nonsense, where they have to know better. My God, what are they teaching these days? Starboard, Bale, UC, Berkeley, Wollongong, Polytechnic. And they don't know this? What do they tell us? Ignorance of the law is no excuse. Right back after you, sycophantic shysters. You're the ones that should know, and either you don't know, or if you do know, that's even worse. And that's another thing they're going to be paying you a lot of money for, is not filing against them for acts of treason to the Constitution. And you'll learn all about that. Send me an email, youwinincourt@gmail.com, because basically the Supreme Court has defined treason as aiding and abetting a court that doesn't have jurisdiction to exercise it, or preventing a court that does have jurisdiction from exercising it. And that, dear friends, is the difference between a federated Republican form of government of defined and limited powers and today's elected despotism. We want it back. Wasn't a perfect government, to be sure, only the best one ever invented. We can go back and make changes from there and do it right. And get rid of all this civil rights nonsense. I mean, the amendment never existed. There was a lot of war acts of Congress that were involved in all that stuff back in the days of Reconstruction. You'll learn all about that. Send me an email, youwinincourt@gmail.com. And just like Nikki Haley said, and you'll be hearing more about her on my videos because I got an interesting situation that involves her in a different scenario. But what did she come out and say recently? The Civil War wasn't about slavery. It wasn't. The big deal there was so the New York bankers could take over the southern states, and elevate these freedmen, quote unquote, to where they're qualified electors, and most of them could hardly read if they could do that at all. But the big deal was so the bankers could control Congress and get any law they want enacted in their favor. That's the bottom line. It was never about civil rights. Black is literally white in this context in American history, as it so often is. To learn more, send me an email, youwinincourt@gmail.com. And we can help make things better for you, your children, and your posterity, and in a big way here, because these people, when you know what the issues are and you know where to go in and insert them, and remember, we have the right to trial by jury. It goes back to the Magna Carta in 1215, for crying out loud. It's still there. And if we do that, we get a default because we're going to serve the other side effective service of process, which is a hell of a lot more than they did for you. And you'll learn more about that big issue too. Send me an email, youwinincourt@gmail.com. But they can't even come into our judicial courts. Can you say default judgment? How good is this? So that said, send me an email, youwinincourt@gmail.com for more information. Subscribe, like the videos, tell your friends, get the word out. The quicker we take action against these bastards, the quicker we make them go away. Thank you.